Patrick?
Then if you're not counsel, the second...
Jacob Biadi? Kennedy Wambua? Edwin Kiprotich? Mwema Kimu? George Kiari? James Charles? Christopher Chalo? Mason Wekesa?
And then you all remove your hood down and your whatever is in your mouth you throw it. Those are not my rules, they are gazetted rules. Kindly. Face mask and the hoods, kindly put them
Mason
down.
Wekesa? Mason? Felix Maweza? 14.
Yeah, 14.
Yes.
All of them are there.
There should be 13. My client Philip Ndegwa Owino is in the hospital.
Felix Mawasa.
Philip Ndegwa Owino.
So number 1 to... How many lawyers are in this one? Taking the
Correspondent, my name is Dan Solomari, together with Anthony Maidia.
Anthony Leshan.
Olesha.
I appear before Umari.
Good afternoon.
My name is Andati. I do appear for the third respondent.
Yes, Your Honor, if you please. I do appear. My name is Brian Heimer. I do wish to place a record for the one of the 6 and the 11 respondents, together with his John.
Yes, appear for the second respondent, together with Mr. Mwangi.
I'm present, Your Honor.
With your kind permission, Your Honor,
Second, yes.
Yes, sir.
Yes.
to represent for coming on record for the 8th, 10th, 12th, 13th, and 14th respondents. 8th, 10th, 12th.
For an interested party, this matter, by the name Martin Kiremi.
Martin?
Kiremi.
Representing you, if not you are standing on your own. First, second, third, fourth, fifth, sixth.
Article 49, 1G and H, in section 36A.
Updated today.
Yes, Your Honor. Your Honor, the application seeks 30 days of custody orders for the 14 respondents to be detained at Capitol Hill Police Station. Now we rely on the grounds on the paper.
You bring for 30 days
30 days
for all of them.
for all of them. Your Honor.
All the accused have advocates. If we take the route of it takes the doc to be cross-examined by all of us, then it will take long. Today is the 23rd. Tomorrow is 24th. Christmas is here. My request could be, let us respond to this application very fast for the court to make a determination, or else we'll be here and we'll be expecting a determination of this matter after 27. That is my humble prayer.
So how much time do you need?
5 minutes.
Verbal, orally, or...
Orally.
Okay, that's okay. Then I'll take him over.
5 minutes. The accused, the suspects, the respondents were arrested way back on Friday. So we have no sufficient time to put in an affidavit. Two, the state is asking for 30 days. because reports are coming and analysis to be done from KEPS, which is an independent government agency. It can take a year to get those reports. The DCI and the DPP cannot direct KEPS as and when to do the analysis. To Your Honor, all the respondents are not required by the DCI when those reports and analysis is going to be done. Third, Your Honor, on the question of interference with the witnesses, authorities that you know, the state knows, say there must be evidence that they have attempted to interfere with witnesses. And it's now settled that mere apprehension by the state is not sufficient to curtail the freedom of respondents. Fourth, Your Honor, all the respondents have cooperated with the police up to now. And I hereby make an application on behalf of all the respondents that they be released on cash bail. The court can set terms and conditions on reasonable terms. On the 25th is Christmas. On 1st is Happy New Year. It must be. And Your Honor, when you look at all of them there, they have children. They have husbands. They have wives. They need to be with their families. Off the cuff, this is a war between cement manufacturers who are billionaires. These are mere pawns being represented by my brother here on pro bono. You want to be kind that they cannot raise a serious amount of cash bail because they can't even afford the lawyers. If the court is gracious with us, you can release them on a cash bail of 100,000 shillings. Their family members who are present can fundraise. No compelling reason as provided for in Article 49, 1H, to deny them liberty at these festive seasons. And I'd like to note, Your Honor, if you detain them, we will not also go because we will continuously be going to take instructions in the police. All these lawyers will be as if they're in prison. That's all. The others can add something, but I'll suggest that the court moves ahead and gives directions on that matter.
Your Honor, maybe just on the only lady who is on that dock, Mr. Omari, has already told the court, Kokebe Meli. Your Honor, liberty, as my land senior, Mr. Omari, has stated, is priceless is a treasure that we all enjoy. And it is also the cardinal value on which civilization rests. Where I've been told that they've been in custody for the last 4 days, and they're here today. They're still willing to comply. Really, suffice to add, the second respondent is a single mother with teens. The youngest is 3, the eldest is 10. We are told that the state wants 30 days. My lady, I'll be urging the court that whereas it is in the interest of the state to protect public interest, we'll be pleading with the court that if the court grants the bail, which is still plead should be as meager as it should, my lady, again, my client as a second respondent will be willing to attend upon having been granted the bail if the court so is so. That is bad law. The law as it is. And as was stated by Justice Murray, with regards to respondents being
I
available.
think they're both judges. Yeah, they're both judges, so one cannot be bad law, good law. It's for the Court of Appeal.
Justice Murray.
Kimaru as it then was.
Same status. Same status. Guided Your Honor.
And we're all lawyers and we learn every day. So we cannot say that one has bad law, the other has good law.
Guided Your Honor. My point is, availing a holding charge to a respondent in court offends the mandatory provisions of Section 123 of the CPC, which requires a charge sheet to be drafted, particulars to be drafted in certainty. Your Honor, we wish to refer you to the reported case by Justice Muredi, the Betty Jemutai Kimera case, miscellaneous criminal application number 26 of 2018.
Miscellaneous?
Application number 26 of 2018. And further, Your Honor, it has been stated that the application before you is brought because there is a tussle between cement manufacturers and the respondents. Your Honor, the application before court has been brought by the state in good faith, emanating from the complaints captured in paragraph 4 and 5 of the affidavit by Sergeant Samuel Tegi. And Your Honor, from those investigations, the grave public interest in the matter outweigh the individual personal interests of the respondents to liberty in this case. We thus declare that the court does allow our application and be guided by the affidavit of Sergeant Itegi, who has deponed as to the reasons as to why he even opposes the respondents being released on cash bail. That is captured at paragraph
Just by the Deep Counsel, Prosecution Counsel. So the witnesses are those ones who have not a long break, because I think I've seen what I need. Allow me to be here at around latest 2:05, 5 minutes past 2 for my ruling. Seeking that the respondents be detained in custody for a period of 30 days at Capitol Hill Police Station within Nairobi. The said application is supported by the affidavit sworn by he in the affidavit, and I quote, is numerous incidents of building collapsing during constructions, and the same is directly attributed to poor quality cement, which is a matter of grave concern due to the lives lost during such incidents, end of quote. That a multi-agency team is in operation and that there are scrupulous businessmen involved in it. Section 123A of the Criminal Procedure Code gives the parameters for the grant of the right to bail as follows. Subject to Article 49(1)(h) of, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular A, the nature of seriousness of the offense, B, the character, associations, and community ties of the accused persons, C, the defendant's record in respect of the fulfillment of obligations under previous grants of bail, D, the strength of the evidence of his having committed the offense. A person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person has previously been granted bail and has failed to surrender to the custody, and that if released on bail, whether or not subject to condition, it is likely that he would fail to surrender to custody. B, should be kept in custody for his own protection. The consideration in determining whether or not to grant bail are set out in the Kenya Judiciary's Bond and Bail Terms Guidelines, March 2015, at page 25, which sets out judicial policy on bail as follows. The following procedures shall apply to the bail hearing. The prosecution shall satisfy the court on a balance of probabilities of the existence of compelling reasons that justify the denial of bail. The prosecution must therefore state the reasons that in its view should persuade the court to deny the accused person bail, including the following: that the accused person is likely to fail to attend court proceedings, B, that the accused person is likely to commit or abet to the commission of a serious offense, C, that the exception to the right to bail stipulated under Section 123 of the Criminal Procedure Code is applicable in the circumstances, or D, that the accused person is likely to endanger the safety of victims, individuals, or the public, E, that the accused person is likely to interfere with the witnesses or evidence, F, that the accused person is likely to endanger national security, or that it is public interest to detain the accused person in custody. It is true that the right to bail is not absolute, and where there are compelling reasons, the said right may be restricted. Nevertheless, since the Constitution expressly confers the right, it is upon the prosecution to show that there exist compelling reasons to deny an accused person's bail. What the compelling reasons are, however, depend on the circumstances of each case. The mere fact thereof that the offense which an accused is charged carries a serious sentence is, however, not necessarily a reason for denial of bail. The ground only becomes a factor if it may be an incentive to the accused to abscond appearing for trial. Therefore, the real question that the court must keep in mind is whether or not the accused will be able to attend the trial, and whether or not the free and fair trial can be achieved notwithstanding the release of accused on bond. In determining whether or not free and fair trial is possible, the court ought to take into account the circumstances of the accused as well as that of the potential witnesses. However, since the release on bond and bail is a constitutional right, it is upon the prosecution to satisfy the court why a free and fair trial is not possible if the accused is so released. In exercising its discretion, the court must seek to strike a balance between protecting the liberty of the individual and safeguarding the proper administration of justice. As the fundamental consideration is the interest of justice, the court will lean in favor of liberty and grant bail where possible, provided the interest of justice will not be prejudiced by this. Conclusively, and the key wordings are for the multi-agency team, the pool of respondents before court seem to be average Kenyans or citizens. The existing problem of collapsing of buildings is definitely a concern, and rightly so. Be that the affordable housing is ongoing, a pool of technocrats can be ascertained in the current setup. This goes a long way on the social and economic policies that Kenya is part and parcel of. However, This court finds that the application to deny the respondents completely bond on the strength of the said affidavit should not deny the said respondents their liberty, albeit investigations. Thus, the following will be the bond and bail terms for each and every one of the respondents. 1. Each accused person is therein granted a bond of $500,000 with one surety of similar amount. 2. Or a cash bail of $200,000 with one contact person. Number 3, which is compulsory, that each respondent to report at Capitol Hill Police Station once a week. Lastly, that this matter will be mentioned on the 5th of February 2025 before this court. Now, this ruling is read and delivered in open court this 23rd day of December 2024 by myself, Honorable Delphina Lego, and all counsels, I believe, are all present. Right? The court assistant is Rabi, and the court prosecutor is Counsel Gashoka. The same is read at 2:38 p.m.
Most of that.
Have your client there because. Okay. These are now pleas, right?
Yes.
Yeah.
Go ahead.
English. Count number 1, the charge is being in possession in the course of trade, counterfeit goods, under section 32, that's really section 35, and the Counterfeit Act. In particular, sir, on the first date in September 2024 at the River Town, within Machakos Town, issued counterfeit cement to one Almasi Karimi, knowing them to be counterfeit goods. Jacob Liadi Wambulo, true or not true?
Not true.
Count number 2. The charge is manufacturing, producing, or making in the course of trade counterfeit goods, contrary to section 32B, as read with the Anti-Counterfeit Act. In particular, sir, on the first date in September 2024 at the River Town, within Machakos Town, County, knowingly altered counterfeit cement, namely Blue Triangle and Simba cement. Jacob Yadi Wambulo, true or not true?
Not true.
The state is not opposed to bond.
The family is trying to fundraise to raise that 200,000 shillings. That is Linya's matter. And therefore plead for leniency so that we can see what else they can get in this particular matter. I also pledge to supply with copies of charge sheets and all documentary evidence that the state will be relying on. That's what we want.
So now, two applications tonight. One is to be issued with all the documentary evidence. Another
You're in the
thing-
same length with.
No, I'm on the.
You're with him.
I'm watching brief for them. No, I'm not with him.
You're watching brief for them.
Complainant. This matter, Almasi Karim.
Yeah, but you will. The prosecution and you are on the same side.
Yes, but you know we have a right of audience.
Yeah, you do.
Yes.
So you want to be supplied.
No, we'll undertake to tell them if you issue an order for the same.
No, it is
At our own
automatic.
cost.
Under the Constitution, it's a right. So
Okay.
just lay us up with the prosecution and should be able to get the documents.
Yes.
Fine.
Nevertheless, Your Honor, we also have a second application. We don't oppose the admission of the accused person to bond. Nevertheless, we submit that the accused person should be admitted to very severe bond terms, Your Honor. For the following reasons: the nature and the gravity of the offense. Your Honor, this is not merely a commercial offense, but Your Honor, is a matter that is touching on a public interest. The second reason, Your Honor, is that the accused person has a criminal record or history. Nevertheless, Your Honor, will not be able to get the evidence as of now. We do that at a later stage. Your Honor, that reason we are asking the court to issue strict contact to the accused person is that, Your Honor, this very accused person is a flight risk. Your Honor. We have reliable information that at the time of his arrest, he escaped.
Now, Counsel, you said your name is Counsel
Bernard.
Bernard.
Yes.
Now, if they million plus one surety or similar amount, or a cash bail of 200,000 plus one contact person, we come back to court for pretrial on the 6th of February 2025. Before
Most
this
of them,
particular court, before